Yes, Oasis Cat. Very quick verdict.
All right, ladies and gentlemen, please be seated. All right, sir, are you the foreman of the jury?
Yes, sir.
It's my understanding that the jury has reached a verdict.
Yes, sir. Yes, Your Honor.
Is it a unanimous verdict?
Yes, Your Honor.
Has it been reduced to writing?
Yes, Your Honor.
Have you signed and dated it as the foreman of the jury?
Yes, Your Honor.
If you would please hand the verdict form to the bailiff.
Did not want lunch.
I ask that the deputy clerk publish the verdict.
In the Superior Court of Liberty County, State of Georgia, case number 2024R-67, State of Georgia versus Nicholas James Kassotis.
Soda.
Count 1, malice murder, guilty.
Done. He's done. He's gone.
Count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 4, concealing death of another, guilty. Count 5, possession of a knife during the commission of a felony, guilty. Count 6, possession of a tool for the commission of a crime, guilty. Count 7, possession of a tool for the commission of a crime, guilty. Count 8, possession of a tool for the commission of a crime, guilty. Count 9, possession of a tool for the commission of a crime, guilty. Count 10, possession of tools for the commission of a crime, guilty. Count 11, removal of the body parts from the scene of the death, guilty. Count 12, tampering with evidence, guilty. On this 14th day of August 2025.
Do the attorneys wish to see the verdict to make sure that it's in proper form?
No, Your Honor.
And are there any objections to the form of the verdict?
No, Your Honor.
Are there any other requests before we go into another hearing?
No requests from the defense, Your Honor.
If I can just have one moment, Your Honor. Nothing concerning the jury, Your Honor.
And does either side wish to place anything on the record before I excuse the jury?
No, Your Honor, and I also don't seek to poll, just for the record.
Nothing from the defense, Your Honor.
Ladies and gentlemen of the jury, we've been here almost 2 weeks, and I wish to thank each and every one of you for your service. It is one of the highest forms of civic duty that any citizen can render to this state and this country, and we cannot resolve important cases like this without your willingness to serve. You've been diligent, you've been here every morning on time, you've been taking notes, you have done excellent work as a juror in this case, and it is sincerely appreciated, not only by me, but everybody involved in the criminal justice system. Your duty ends at this point, and I'm going to have to go into a sentencing hearing. There is one other thing that I do want to mention to you. I think you knew at the outset that this case was going to be televised, live streamed through various media outlets. And I want you to know that you have a right as a juror and as a private citizen. People may want to talk to you about this. Well, at this point, you can talk about it if you want to. That's totally within your discretion. It's my understanding that some of the media outlets may be outside. They may want to speak to you. That's solely up to you. I have no control over that. That's up to you. So when you see individuals who might be with the press or other outlets, that if you want to speak to them, that's fine. And if you don't want to speak to them, that's also fine. So there's nothing else I can tell you other than I sincerely appreciate your hard work in this case. I wish you well, and you are excused at this time. Thank you very much.
All right, we're real time, so we can't skip ahead. We're going to get into sentencing, and I mean, guys, victim impact or no? Do you think he's going to make a statement? I think he's going to want to say something to the judge,
Yes, ma'am.
and I don't think it'll help. Yep, guilty on all counts. I could update the banner. All right, so banner is updated. Oh, wait. Guilty.
Everyone, please be seated. And I want to tell all of you, thank you very much for your service. But the reason we select alternates is someone who is sick or not able to perform the duties of the juror, you were going to fill in. But your work was also very helpful.
I feel like Doug would guide him to just be quiet, let him do the talking. I mean, there's not much mitigation to do here.
All right, ladies and gentlemen, we'll be in recess for about 10 minutes, and then we will begin the sentencing hearing.
Thank you, Your Honor.
Yeah, and again, I'm going to pull the counts back up on the screen, but malice murder and the separate charge of felony murder could both get him. He's looking at life sentences for both of those. So I don't think there's anything to mitigate here. There's not going to be something that makes him eligible for parole. They didn't raise an insanity defense. Oh, sorry, Cupcake. Well, unless you wanted to be here, then I'm glad, but sorry at the same time. Woke you out of your sleep when you heard, here we go. Yeah, Aaron. Also, Aaron, thank you. Hurricane Aaron is deciding to, it seems like, stay away from the Florida coast. So thanks, Aaron, for staying away from me. But Aaron says, I feel bad for Doug. I really hope Kassotis doesn't make a statement at sentencing, but I'm not confident he's learned to shut up yet. Me either. Oh. And I do feel I don't know what the true story about his family members are. It seems like that DV story could have been fabricated just as an excuse. And maybe the dad willingly participated in the reporting of this scary incident involving family members to help get the name change filed under seal. But they weren't called to the stand. We don't actually know what they were complicit in at all, if at all. So I don't know if they're just wondering what went wrong. I don't know. That part is a mystery to me, but I would imagine that we might get some victim impact statements. We see that Morgan Paddock is in the gallery. I didn't see Angela, but Angela, it seems like she had to fly in to testify, so she might just not be available. But I wonder if we'll get a statement from the friend, Morgan. Yep. And what's twisted too is, this whole thing about the PCOS and how Nicholas Kassotis tells us, he gets up there and tells us he was trying to get Heather to take medication so she could get pregnant. It's like, could the same fate have met Heather if they stayed together longer and she wasn't able to carry his child? Could the same fate have happened to Samantha? Yeah, and Travis B says that name change sealed it for him, that he tried to conceal his identity in relation, like because of the murder. And that's the thing, I really, and I don't love the way that the prosecutor did it. There are a lot of people that love the way the prosecutor was emotional during the closing. I don't love that style. I think her acting out the stabbing motions for the marks near the belly button, I think it was inappropriate because we didn't have, it's too far of a inference for me to find it reasonable. Because she didn't ask very many questions of the medical examiner. We got that there were 3 defects on the belly that could be consistent with a sharp object, but she didn't ask any questions consistent with a stabbing. Now, something being caused by a sharp object does not necessarily mean it was caused by a stabbing or penetration. She didn't ask any questions. It was like 10 seconds of discussion about these defects near the belly. And Doug didn't ask about it in cross because he focused on the head lacerations and discoloration that were really the breadth of the questions on direct from the prosecution. And then in closing, Lori Bale gets out there and yells, "And you're angry!" and is making repeated stabbing motions while describing what we heard in evidence was only defects consistent with the sharp object on the belly. We don't know if they were post or pre-mortem, but nevertheless, I think that was very compelling for the jury to get to that malice murder. Whereas people were confused about this theory of, initially the state, they were on the run together. He did all of this to avoid a $1.5 million judgment that was awarded against his wife, Heather. And cool, I can kind of see how you could get there, but when you have evidence on the record that that judgment was pending for years already and nobody was harmed, now it's kind of like, I don't know if that really makes sense as the why. But the state got a cohesive why together. I don't like the animation in illustrating how they think wounds were caused. We don't have testimony from the ME, but that is what it is. I'll invite Doug up. Doug's welcome to come up here anytime. Yeah, Sabat, I agree. The shouting is just wild. The shouting is too much for me. It's just not my taste, but and I think a lot of us don't love that because we just want to hear the arguments here. But there are a lot of people, I think the overwhelming amount of people that follow trials, especially the true crime genre. They really are here for the victim. For them, trials are about the victim. To me, I diverge there. I think trials are about the case against the accused, and if the state can meet their burden to prove what they're charging against the accused. But there's other people that look at cases as having a different purpose. And ultimately, I want to be clear, I diverge on my characterization, but I come back together where if the process is followed correctly, the prosecution is all the T's are crossed, I's are dotted, it ultimately results in justice for the victims. So I diverge and then converge back at the same end goal, ultimately. D.A. Hilton wants to come up and talk to us. She's going to be like, look, I love the phrase I submit to you. So, and I think, let's do a poll. Not a poll, but a percentage. Let's do out of 100%, the chance of a guilty verdict all the way down the line. So if you don't think it's guilty on 1 or 2 charges, reduce your percentage a little bit. Do you think without Nicholas Kassotis taking the stand, do you think it was like 100% chance the jury's still going to find him guilty? Or how much damage, if he didn't testify, what percentage chance do you think this full down the line verdict would be? Because I'm honestly at like a 80, 85. I think he would have been found guilty of all the concealing and hiding. So my opinion is I think we cleared the burden on all of the dismemberment and clearing and concealing and the tools that, maybe not specific all the tools, but at that point before he took the stand, it could have just been he found her unresponsive and wanted to get rid of the body. Maybe we're not sure beyond a reasonable doubt that she was actually, her cause of death was him intentionally planning to kill her. He got up there, he sealed that for me. So let's see, let's go back to the start. We've got, starting with, I think this is the first one, 100%, 40, 100, 60, 100, 100, 67, 100, 50, 50, 60. I love it. This is 96. It's so precise. 65, 70, 50, 30. Without him, yep, 85. All right, 75. I don't know if this is 445 or 45. 95.5, 100, 60, 50. Skillet breaks it down, because once we let this roll out, these answers, because I think they said 10-minute break, right? Guilty without talking, guilty with talking. He should have just ate the special fried rice in his cell alone. Yeah. He did have those chatty patty interviews. Morris is over 90. Jury was mad at him. Guilty. Well, I don't know if Steele necessarily would have gotten a different outcome. I think the best chance at a change in outcome would be if guidance was followed to not take the stand. 45. 3? Mara says it's just the police interview. Police interview did it. Anna goes 75 to 100 after the testimony. 90. Travis B. Yeah. Eve, and I think the same. Mindy's failure to get and keep the pregnancy sealed the fate. And I don't think that was that cohesive of a why until he took the stand. It was just my speculation. I was thinking about it. I was mulling it over. And I could see how the jury might say, well, I think this guy would think something like that. But a reasonable doubt standard, I really think his own testimony just nail in the coffin. And O'Bailey's, and I like this see the nuance. The state didn't prove he was the one who cut the bones, for me anyway. And, big questions about tool mark analysis as a general question, right? So that's why I always think a case like this is interesting, because we get to see what tool mark analysts present, how they're cross-examined, what they are capable of looking at, what they can't look at, what the state gives them to look at. They're really working with, hey, this Milwaukee knife, insulation knife, is the suspect weapon. So they have that constraint while they're going into it, looking at it. We got 100, we got a 95, 100. We got 100 here. Candace says, I submit to you 100. 100. And also, even if he didn't testify at all, nothing he said made sense. Where is everyone's brains? Well, and so Joyce, I think you're welcome along. But I think we look at the case with, I try to frame a lot of my questions with predictions on what the jury is going to do. And if I'm going to ask for personal opinion, sometimes what do you specifically think? What would you do? And I think picking a jury, there's a lot of value in understanding that juries can be unpredictable. So when we have most of the chat here saying they think the jury still would have come back 100%, 95, 80% or higher with guilty, I think that's people agreeing with you more than you think. Um, let's see. Yeah, Max, I do wonder if he didn't testify, the jury might have been out longer. Um, I think they might have wanted to rehear his own words, right? Because just because the nature of listening to these recorded interview calls, it's hard to hear. And if that's their chance to go and hear his words again, maybe they would have asked to see those replays. So, and so Joyce, I think the way you're approaching here in the chat, and I want to welcome you here, and if you're open-minded to having a conversation, you're absolutely welcome here. But to ask a question like, does anyone realize? It's really dismissive when the majority of this chat while we were going through that subject matter was shocked, was asking questions, was saying, how would nobody know what the hospital was actually saying? How would nobody of the family members have an actual say or an opportunity to speak with somebody and get some questions answered? So it's, I think you might be speaking from a place of emotion and surprise. And I think the surprise is unfounded. And I think this is quite a presumptuous position to take against this chat here. Because this chat, by and large, was shocked multiple times at the stories being told about the hospital story. But I understand it's an emotional case. There's a huge sadness here. Let's see.
Council ready
Oh,
to
we got some
proceed?
movement.
Okay, everyone please be seated. All right, in case number 2024 R67, the jury having reached a verdict of guilty as to all 12 counts in the indictment, is the state ready to proceed with sentencing?
The state is ready to proceed with sentencing, Your Honor.
Is the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Does the state have evidence in aggravation?
Yes, Your Honor. The state intends to call two witnesses and one statement that I will ask Ms. Ashdown, our victim witness advocate, to read. So the state would call, would the court like me to proceed?
Yes, ma'am.
At this time, the state would call Megan Mevin to the stand. Ms. Mevin will be speaking on behalf of the family of
This is
Mindy
Frank's.
Mevin, Your Honor.
This is Frank the Fourth's wife,
Do you-
Megan Mebane.
I'll let- She might be more comfortable just sitting up there. Please raise your right hand before you're seated.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I just ran up the stairs, so sorry if I'm.
Just hold on. Just catch your breath.
Okay, let's see. All right. I've kept up with the entire trial and decided to drive 3 hours this morning to be here because I couldn't let this chapter of my life end without at least saying something. Unlike you, I have cried a lot over the last few weeks. My thoughts, anxiety, and emotions have been a roller coaster. They have been all over the place while having to deal with this trial. I go through anger, sadness, frustration, grief, stress, and every feeling that you can think of. You lived with us for 15 months with providing no financial contributions. 15 months that I will never be able to get back. At times when you lived with us, I told you how your actions had affected me, and this impact statement isn't much different. Whether you take away anything from this, that is not my intention at this point. You've shown no guilt and absolutely no remorse. You haven't even shed a tear. You thrive on the illusion of power and attention. You're a pathological liar, sociopath, psychopath, murderer. You thought you were so much smarter than everyone else, but you aren't. You wanted people to believe you were a victim of abuse, while you were the one being abusive, at least mentally. You have forever changed the meaning of trust for me and our family. I can no longer trust people in the same way as I did before you continuously lied and ultimately took Mindy's life. There will always be some questions that will go unanswered, but to answer them would mean to try to understand a murderer's mindset, and that is one I will never understand. Mindy was bright, beautiful, empathetic, confident, independent. She loved music and making others feel special. She always put her family and friends first. Once my husband Frank and I had our daughter, Mindy wanted to choose a name that was different than the traditional aunt name. She decided on Lulu. She was never able to hear her sweet niece call her that. My daughter was 5 months old when y'all moved in. She will never know the fun times they experienced together. I'm thankful my daughter does not remember the 15 months you lived with us and sat right next to her at the dinner table. My daughter will never be able to experience the love her Aunt Mindy would have continued to give her. Mindy was taken too soon. No one should have to live through the violent and gruesome murder of a family member. You're a very evil man. When I learned the news of what really happened to Minnie, some of my first thoughts were that I couldn't believe that evil man lived in my house in a bedroom next to my 5-month-old daughter. You have no remorse for what you did. This loss has impacted so many beyond our family. The emotional wound you have caused will never heal. We have comfort knowing she is in heaven now, free from the trials and scars of this earth. We have overcome hatred, darkness, and evil. She is looking down on us now, being proud of how we have overcome. We are done being victims. We are taking back our lives. Since I'm a science person, I'm going to quote Isaac Newton. Every action has an equal and opposite reaction. Our family believes you deserve the maximum sentence, life without the possibility of parole, because Mindy doesn't have a parole. You deserve to sit in prison for the rest of your life and think about Mindy every single day. Thank you, Your Honor.
Thank you.
Your Honor, at this time, the state would call Morgan Paddock.
Okay, Morgan is the first friend that we heard from. The one that said they were like friends in the church, the youth group.
You can raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
There are people literally all over this world that have been impacted by Mindy's life, and I'm here to speak on behalf of them. I always say my worlds collided with Mindy. Not only was she my high school friend, but after moving to Savannah, all of my college friends became her friends too. My roommates became her roommates. My church group became her church group. This entire trial has rightly been focused on what happened to Mindy, but Mindy was so much more than what happened to her. She was a bright light, vibrant, generous, funny, caring, a defender of others, passionate, trustworthy, and so much more. If anyone in her life would have been in her position, she would be standing right here today speaking for them. Nick, you slowly and strategically tried to dampen her light, isolating her from the people she deeply loved, robbing her of time, laughter, creating memories and peace, always living in fear and isolation. She loved you and trusted you to tell her the truth, to protect her, to live out your marriage vows, and yet you were the one that she needed protection from. Her death has had and will have an eternal impact on those that loved her. There are dinner tables and holiday pictures and memories that will be absent of her. There are little girls growing up without their fairy godmother. There are friends who will always ache to dress up and go out for drinks again. Email inboxes void of her opinions on the latest happenings in politics. Friends who can't expect her to stand with them in their proudest and hardest moments. Friends who won't have her in the audience of their concerts or harassing them for their latest released music. My everyday life in Savannah is now filled with the awareness that my friend was living and suffering within walking distance of my house. And I never knew. I will never be able to drive down
That
65th
sucks.
Street, go to a Smoothie King, pick up meds at CVS, or buy tennis shoes at our local shoe store without being haunted by the fact that you were frequenting all of those places for 5 months while my friend of over 20 years was suffering in fear and isolation as I drove mere feet from her driveway. But it's not just me and her friends that will miss out. This entire world is impacted by the ending of her life too soon. There are compelling women whose stories she will never get to tell on her podcast. There are strangers who will never know the beauty of the sound of her laughter or the impact of her most fiercest eye roll. Your conviction can't bring her back. It just means that you can't do it to anyone else. But every person you heard from on the stand and the many who are watching right now from a distance will never stop keeping the truth of who she was and her memory alive. You may have taken her life, but you will never be able to take her legacy, and she would want you to know that today.
Pausing quick, there is a company called Help Text, and I'm sure there's variations and all of that, but I know a lot of people don't like the idea or don't have it's not possible to go and get counseling. But there is a very real type of grief where you're the friend that feels like you didn't do enough to help somebody. And it's a company that we used to use in the probate space when someone would lose a family member and not know how to deal with their grief, or felt like because they weren't somebody's best friend or direct family member that their grief wasn't okay to have. I think more awareness could be made for that layer of grief when you're kind of removed from somebody when they pass away, but you feel remorse that you weren't there. And there is counseling for that. Help Text is a service that we used to provide to people that were in that situation because they would curate their support for you to that type of thing. Really, it's a really strange type of grief to deal with. And Candace says grief share group. Is that like a Facebook, like a social media group?
Your Honor, the state has one final statement that I'm going to ask to be read into the record. That statement would be read by Ms. Samantha Ashdown, our victim witness advocate, on behalf of Samantha Kolyesnik.
All right.
The defense will object to the reading of that statement as Ms. Kolyesnik, while obviously a victim of the circumstances here, is not a victim under the law that would be entitled to read the statement to the court.
Well, Judge, my position on that, as the court is aware, is that this is evidence in aggravation, not a victim impact statement.
It is, and I'll overrule the objection. Thank you, sir.
Thank you, Your Honor.
Yes. There's no need to swear.
To the court and to the Honorable Judge Rose, my name is Samantha Kolesnik, and I am a victim of the defendant Nicholas Kassotis, aka Nicholas Stark, the latter of which is the name he used while victimizing me in Pennsylvania. You were able to hear my testimony against Nicholas during this trial, and you were able to hear and see my pain and my tears firsthand. I recounted his horrible acts of deception against me. I trembled taking the stand to testify. It was the hardest thing I've ever had to do, but I did it because I feel Nicholas is a true and constant danger to everyone he meets. I feel that if given the chance, Nicholas will continue to exploit, abuse, deceive, and harm others. I testified knowing I would be filmed against my consent and that I would be humiliated in admitting I was defrauded by a man I met online, and that my privacy would be forever gone. I testified anyway because I strongly feel and believe that Nicholas is a danger to society and that he must be held accountable. Ms. Bayo, ADA for the prosecution, mentioned ripples from Nicholas's dropping stone as an analogy for an impact of his choices. I am one ripple. I have not been the same since I found out about his deception from Agent Sands, and I will never be the same again. On the date of his arrest, when Agent Sands of the GBI told me Nicholas Stark was not his real name and that Nicholas had been lying to me, my entire world turned upside down. My sense of trust shattered. I felt humiliated, deceived, traumatized, and unsure if I would ever be able to feel joy or hope or trust again. I also felt stupid and will continuously be called stupid and gullible by some in the public eye as a result of trusting a man who was once a naval officer, a JAG, an employee of the Pentagon, a man who had every opportunity and privilege in life. Everyone trusted Nicholas, and he knew it, and he privately relished and delighted in lying to them and in abusing that trust. He is a man who delights in deception, a man who thinks he's smarter than everyone in the room he walks in. I also felt terrified beginning on the date of his arrest and thereafter, and will forever be haunted by what he would have potentially happened to me if the GBI and Detective Jack Frost's team had not tracked, found, and arrested Nicholas Stark, aka Kassotis, when they did. I fully believe that the wonderful law enforcement agencies of Georgia saved my life that day, and I will be forever grateful to them for saving me from the evil man who goes by many names, one of them being Nicholas Stark. I was diagnosed with PTSD, post-traumatic stress disorder, as a result of Nicholas Stark's cruel actions towards me. I have nightmares, flashbacks, and panic attacks. I lock my bedroom door every night. I do not feel deceived by Nicholas Stark, aka Kassotis. I feel raped by him. I was not allowed to consent to a romantic and intimate relationship with Nicholas because he lied about his entire identity to me. There was no opportunity for true consent, and he ensured that with his vast network of lies. This is called rape by fraud, but unfortunately is not recognized in Pennsylvania, so all I could do was pursue an annulment on the basis of his fraud. I am sure Nicholas Stark, since he is a lawyer after all, knew those statutory limitations when he deceived me. I do not feel Nicholas feels 1 ounce of shame or remorse for his deceptions against many people, including those he perpetrated against me. He has sat in this courtroom and has attempted to make every mockery of it with his smug expressions, his arrogant demeanor, and his lack of tears as his victims, one after the other, have talked about how he deceived them. I beg and implore and plead to the court, please give this man the maximum sentencing. And please, if at all possible, by sentencing protocol and legislation, please do not allow this man to do paid interviews or in any way profit from his crimes. Nicholas, due to his sick need for control and his sadistic desire to humiliate and defraud others, will absolutely try to profit off his crimes in prison. Please do not allow Nicholas to write books or to sign movie deals or even take paid interviews. He must not be allowed to extract any more from the victims than he already has taken so much. I also ask that he not be granted any chance for parole. A man who lies as much as Nicholas has and will always be a danger to society, especially the most trusting and vulnerable among us. Sincerely, Samantha Kolyasnik.
Thank you.
Georgia does not have a
Those are
son
the
of Sam
only
type law.
evidence of, aggravation that the state intends to present. Do you wish the state's argument, or do you wish to have
I'll wait
mitigation
till I hear
first?
from the defense.
Certainly, Your Honor.
Does the defense have any evidence in mitigation?
Just like to present the defendant's mother to testify in mitigation.
You may.
So this is going to be Linda Kassotis.
One at a time. So, two, yes, Your Honor. Defense calls Wayne Kassotis.
You can come up here, sir.
Yes, Wayne.
That's fine.
Thank you.
Can we swear you in, sir?
Oh, absolutely.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely. Good morning, Your Honor.
Yes, sir.
Heard a lot of things in this courtroom this morning. Last over 2 years have been hell for all of us, including Nicholas. Although I don't agree with the verdict that was reached in this court, that the jury reached, I do respect the process. They have no idea who Nicholas was. Nicholas is a kind, gentle man that has touched thousands of lives, both as a civilian and as a military person. Nobody saw pictures of him helping underprivileged children in South America as a naval officer. Nobody saw him helping friends as he was growing up. He is truly a wonderful, kind person. And from the beginning, when this all broke, from the lies that Agent Sand told to family members, we never believed that this was possible, and we still do not believe that this is possible. We know the person sitting there, our son, as a kind and gentle person that would not do this, and there's really no evidence that showed that he did. I just want you to be considerate and look at the man who he is and who always will be. Thank you, Your Honor.
Thank you, Mr. Kassotis.
I mean, I think the judge is going to look at the man he is and will always be. And I put it in the chat, but since I didn't say it out loud, if you're just listening, so Wayne Kassotis has former law enforcement experience. He was a police chief. He seems to be retired now. But I think that is why we get but I respect the process, right? You know, he probably had to testify and help put cases on. So that was to me, very consistent with a law enforcement officer saying that, or something that a prosecutor would say in a statement after trial to the media. And here he's saying it in a victim impact, a statement asking the court for some type of sympathy for his son before sentencing. So that was interesting wording.
Thank you very much.
The defense calls the defendant's mother Linda Kassotis.
Now this is Linda.
Ma'am, you're welcome to stand here, or you can go up there.
Stand here.
If you would please raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you.
Your Honor, I would like to say first how incredibly sorry we are for Mindy's family that they had to go through this. We have never spoken since we heard the news of Mindy's death, but we feel incredible sympathy for them that they lost their daughter. But Nicholas was not responsible for this. We know him to be a kind and gentle person. As you know from the testimony, we had not been in touch with him for years through circumstances beyond our control, and every member of our family suffered as a result of that. People missed him so desperately. My mother said she had never gone a Christmas without seeing or hearing from him, and suddenly he was gone from our lives, and we had no idea why. He is a good and kind and gentle person. The thought that he could take someone else's life is just unbelievable, honestly. I respect the jury's work that they did, but they got this one wrong. I'm sorry. Thank you.
Thank you. Anything else, Mr. Constant?
No, Your Honor.
All right, this time I'll hear argument from counsel.
Your Honor, may I?
You may.
Your Honor, this case is a case that the court has obviously spent the last 2 weeks present for and listening to all of the testimony. As a result, I don't plan to go over any of that. I think Morgan may have said it best when she described how Mindy and her life impacts the world. When a sentence is rendered, I think the court has always, and I think I've even heard you say, has to evaluate not just how it impacts the defendant, but the message of rehabilitation, if possible, versus punishment, if necessary. The law in the state of Georgia entitles on a murder conviction only 3 options, essentially: the death penalty, life without parole, or life with the possibility of parole. In this case, Your Honor, the defendant is additionally facing all of the additional crimes that can run consecutively. That would be the concealing death of another, which he faces up to 10 years, possession of a knife during commission of a felony, which is mandatory 5 years consecutive, although it could be, of course, probated. And then all of the counts of possession of tools for the commission of the crime that he's facing up to 5 years for each of those. And then the 2 misdemeanors are, of course, up to 12 months. That is more than what I would refer to as natural life. The state's position, Your Honor, is that the defendant should never be released from prison, that he is a danger to society, that his testimony before this court under oath was fraud, that he was dishonest, that he perjured himself, and that, of course, is the state's position. I'm sure counsel for the defense would disagree, and I think that goes to the question, however, of whether or not there is remorse or whether there is some validation to something less than life without parole. The jury has now determined that he not only killed his wife, but that he threw her out like garbage across 3 miles with the hope that no one would ever catch him. If that depravity could not be any worse conduct to deserve life without the possibility of parole, I don't know what could. But for the good work of members of law enforcement, all of the teams that worked so hard to run every detail down, we would not be here today. And so, Your Honor, it is the state's position that the defendant in this case should get the maximum sentence of life without the possibility of parole. The state will defer to the court with respect to all of the other counts, as I essentially believe that they are, you can't get more than forever. Thank you.
Thank you, Ms. Dale.
Your Honor, the jury has rendered its verdict. While obviously we don't agree with that, we understand that is your obligation to sentence him under that verdict. Mr. Kassotis is a highly educated man. He's a man that served his country honorably. You've heard a lot of testimony, not just from his parents, but from witnesses on the stand of his kindness. I think there is an opportunity for rehabilitation in this case, especially given his past. So I would ask the court to sentence him to life with the possibility of parole. Those other counts that can be served concurrently, that the sentence have them served concurrently. I understand there's one count that must be consecutive. So that's the position of the defense, Your Honor.
And Mr. Weinstein, your client has the right to address the court if he so chooses.
Let me verify.
Oh, he said no.
He will not be addressing the court, Your Honor.
Then have him stand for sentencing. Mr. Kassotis, a jury of 12 citizens in Liberty County, Georgia, has now determined beyond a reasonable doubt that you are guilty of the offense of murder, along with 11 other counts. This jury has spoken very clearly. It is now my duty under the law to impose a sentence that is consistent with that verdict. It is also my duty to look at the evidence and weigh the sufficiency of that evidence. And sir, the evidence in this case is supported by a mountain of compelling evidence. This case has revealed a level of depravity that truly shocks the conscience.
No parole.
To put together this elaborate scheme, this web of lies, creating this fictional character, Jim McIntyre, who does not exist. You wrote fiction, and your life was a fiction, at least the last 6 or 7 years. And then you carried out, or the evidence shows that you carried out a brutal, horrific, gruesome murder of Mindy, someone who's been described by various witnesses as beautiful, kind, loving, vibrant, smart. And all of her hopes and dreams vanished in an instant. Her life tragically cut short by you. Someone who professed to love her, to care for her. Just the ultimate betrayal. And then you desecrated her body in such a vile way, discarding her remains out in a rural area of Liberty County, hoping that they would never be discovered. This shows beyond all doubt that you have no conscience. When I described to this jury this morning the elements of the crime of malice murder, the language used in the Georgia statute is that the circumstances show an abandoned and malignant heart. That describes you. You have caused so much harm to your own family, to all of those who have been impacted by your deeds. This is truly a heinous crime. So the court has considered all the facts and circumstances of the case, And the court will now impose sentence that reflects the gruesome nature of your criminal conduct.
Done.
As to count 1, malice murder, the court hereby imposes a sentence of life without the possibility of parole. Although you've been convicted in count 2 of felony murder, that count would merge into count 1. As to count 3, the sentence of the court for aggravated assault is 20 years to serve in the state penitentiary, and it runs consecutive to count 1. Count 4, concealing the death of another, the sentence of the court is 10 years to run concurrently to count 1. Count 5, possession of a knife during the commission of a felony, it's required to be consecutive, so the court imposes a sentence of 5 years consecutive to count 1. As to count 6, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to serve, and that shall run concurrently to the other counts. Court will impose the same sentence on count 7, 5 years to serve, running concurrently. As to count 8, possession of tools for the commission of a crime, again, the court will impose a sentence of 5 years to run concurrently. As to count 9, possession of tools for the commission of a crime, the court imposes a sentence of 5 years, again to serve concurrently. As to count 10, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to be served concurrently. Counts 11 and 12 are both misdemeanors. They carry a maximum sentence of 12 months. The court will impose a sentence of 12 months as to each count, counts 11 and 12, and they shall run concurrently. The totality of the sentence being a sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your convictions of these crimes, and you can do that by filing a motion for new trial or filing a direct appeal to the appellate court. That will have to be filed within 30 days of today's date with the clerk of Superior Court in Liberty County, Georgia. If a motion for new trial is made and the court denies it, you will then have 30 days from the filing of that order to file with the clerk a notice of appeal to the appellate level. You also have a right to file a petition for habeas corpus. And that would have to be filed within 4 years of the date that the sentence and judgment in this case is deemed to be final. If you cannot afford an attorney to pursue your appellate relief, a lawyer will be appointed for you, and I'm sure that Mr. Weinstein will discuss with you all of your appellate rights. Is there anything else that needs to be placed on the record before the defendant is remanded to custody?
Your Honor, I just want to clarify, the court indicated life without parole for count 1, 20 years to serve consecutive on count 3, and 5 years to serve consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the record was
I
correct.
misspoke.
Thank you, sir.
25?
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's
You
the
said
only
25, right?
position statement.
Toward-
Consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the
25.
record was
I
correct.
misspoke.
Thank you, sir.
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's the only position statement.
He is remanded to custody. Court stands adjourned.
Thank you, Your Honor.
Right, so let me correct that real quick. All right, so short and sweet, really there for sentencing. I'm still curious. I thought Georgia had a son of Sam law, which would, that's the type of, son of Sam prevents someone from profiteering off the circumstances that got them incarcerated. Like they can't do interviews for profit, things like that. They can't write books and make a profit off of it. I thought Georgia had something similar, and maybe they do, and maybe Samantha included that in her statement. She lives in Pennsylvania. Maybe they don't have that there. But yeah, there wasn't a term of sentencing specified by the judge here to prevent that profiteering. But I do think it's just barred in Georgia anyway. Okay, so let's see. Yeah, look at Justice Serve TV with the numbers here. I tried to Google and then got distracted with the stream, so big thank you here to Justice Serve TV. We love them. And there we go. Let me link in the chat. And we're going to get back over to the Fulton County case, but let's take a look at this. So this is dealing with restitution and distribution of profits to victims of crimes. And then we've got distribution of profits of crimes, contract regarding reenactment of crime, deposit of consideration in escrow, monies, actions taken to defeat purpose. So this first section, 1, every person, firm, corporation, partnership, association, or other legal entity contracting with any person or with the representative or assignee of any person who's been accused or convicted of a crime in the state with respect to the reenactment of the crime. So, I mean, that my mother-in-law, Betsy, is poisoning me, and I think I know why. That's the short story that he had received $300,000 for. Sony purchased the rights to it. Seems pretty relevant to some of the stuff here. But movie, book, magazine article, tape recording, phonograph record, radio or television presentation, or live entertainment of any kind, or with respect to the expression of the accused or convicted person's thoughts, feelings, opinions. Let's make this bigger because this is real tiny for you guys. All right. Or emotions regarding the crime, shall submit a copy of the contract to the board and shall pay over to the board any monies which would otherwise, by the terms of the contract, be owing to the accused or convicted person or to his representatives. Board's got to deposit the monies in an escrow account for the benefit of and payable to any victim or the legal representative of any victims of crimes committed by the accused or convicted person. 3, payments may be made pursuant to paragraph 2 of the subsection only if the accused person is eventually convicted or enters a plea of guilty of the crime of the victim. So we've got that conviction now. Within 5 years of the date of the establishment of the escrow account, brings a civil action in a court of competent jurisdiction, and recovers a money judgment for damages against the convicted or accused person or his representatives. It shall be the duty of the victim's attorney, or the victim's representative to notify the board within 30 days of the filing of any claim under this article. So it seems like the income isn't just barred statutorily, but follow this process and any profits from these related materials will go into an escrow account to be used to pay victims or counsel for victims if they follow the process here. So let's see. And also catching this, Aaron, exactly this. Aaron, and I think Aaron's also agreeing with Neri. Those are like the same names. If we switch them, you guys could spell each other's names. Same, I didn't love the prosecutor's style, but I'll take that over misconduct any day. 1,000,000%. And this is the thing, guys. I think Doug did a great job. Prosecution might not have been my cup of tea stylistically, but I think she did a great job. I think she brought the case home in closing, even though she yelled. But those are two sides of the puzzle to make sure the conviction sticks, right? I mean, I don't think we're going to have any issues on appeal that succeed on arguing ineffective assistance of counsel on Doug's part. I don't think we're going to have prosecutorial misconduct. Nothing's really pointed in that direction. And that's what you want for the process to stick. That's where those roads, I might diverge. I don't think trials are about victims. I think trials are about the accusations being brought against the defendant, but they converge when the process is right. So, the Sony deal, it was a little more than $300K, I think, because they mentioned payments to an agent, but it was $300K and some percentage. $300K was deposited to, I almost said Jim, to Nicholas Kassotis. It was for the purchase rights of a short story he wrote that was published on the No Sleep subreddit, got a lot of attention and praise. And I don't know what they plan to do with it, but so yeah. Now this is more about, I think, on the process. So let's just see how Georgia does it. At least once every 6 months for 5 years from the date it receives such monies. So the board shall cause to have published a legal notice in newspapers. So they got to publish, similar when someone dies, you got to publish a notice to creditors. If anyone has an interest in making a claim here, you have to publicize the notification. But general circulation in the county in which the crime was committed and in counties contiguous to such county, advising victims of the crime that escrow monies are available to satisfy money judgments pursuant to this code section. Oh man, there's a lot of people in this case, it sounds like, that might have some interest here. Upon dismissal of charges or acquittal of any accused person, the board shall immediately pay over to the accused person the monies in the escrow account established on behalf of the accused person. So if I would assume this applies if there's an overturning of the conviction, which I don't see happening. Upon a showing by any convicted person, so this is where it's not a full-on Son of Sam law. Upon a showing by any convicted person that 5 years have elapsed from the establishment of the escrow account and that no actions are pending against the convicted person pursuant to this code section. So no one makes a claim, no claim is being granted. The board shall immediately pay over any monies in the escrow account to the person or his legal representative. So that's why it's not a blanket Son of Sam. He can make the profit, but if people have a claim or there's judgments and they follow this process, they've got this 5-year window to say, hey, bring it this way. Bring it this way. Whenever it is found that a person accused of a crime is unfit to proceed to trial as a result of insanity, and we didn't get that here, guys. So I know there's been a lot of commentary like, is he missing? Is there a diagnosis? No, could he be diagnosed? It wasn't argued. It wasn't part of the trial record. And it didn't really become part of mitigation at all either. So, I mean, this is not applicable here. Any excess which remains in the escrow account or is deposited into the account after all money judgments have been satisfied. I don't know if we'll get to that amount of earnings, depending on if everyone stakes their claim, shall be paid over to the state treasury as compensation for the establishment, administration, and execution of this article. Board shall make payments from the escrow account to any person accused or convicted of the crime upon the order of a court, all right, blah, 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 blah. And it can be used for the exclusive purpose of retaining legal representation at any stage of the proceeding against the person, including the appeals process. So right now, Doug's substitution of counsel was approved by the public defender's office, so I don't think that Nick has any money coming in. But if he does, it could first go to affording counsel, paying for counsel for this appeals process. Board shall disperse payment from the escrow accounts on a pro rata basis for all claims filed according to the amount of money in the escrow account as compared to the amount of each claim. The sums are not to be dispersed until all pending claims have been settled or reduced to judgment. Any action taken by a person who is accused or convicted of a crime or who enters a plea of guilty, whether by way of execution of a power of attorney, creation of corporate entities, or otherwise. Oh man, creation of corporate entities. I'm sorry, I'm just thinking of how Nicholas Kassotis was acting like he didn't know what a W-4 was, and all these other businesses that merged and got renamed as Apis Limited, or otherwise, to defeat the purpose of this code section shall be null and void as against the public policy of the state. So you're not going to run a bit of gamesmanship to get around this. So this is really cool. Shout out to Justice Serve TV. I like learning stuff like this. You know, we talk a lot about Georgia, but even so, when things are state specific like this, there's the little granularities, the nuances. And let me get their link here. Go and say hey to them. They're going to be talking about this case tonight at 6 p.m. Eastern. Link is in the chat, and